My name is Chris Karani. I'm with the law firm of McAndrews, Held & Malloy. We're a IP boutique firm in Chicago. We have about 105 attorneys practicing various areas of patent law, trademark, and copyright law. What I would like to speak about today is U.S. design patent protection. This particular topic has become increasingly more important. I know we perhaps have quite a few trademark attorneys. There is quite a bit of an association with, say, trade dress law and design patent law. One thing you'll note, I know we have a very much of an international audience here, is I will be referring it because in the U.S. we consider them design patents. Many other countries, they're design registrations, industrial designs. But here in the U.S., it's actually a design patent. So it falls underneath the gamut of 35 U.S.C., which is our patent law. I think the discussion is particularly timely, and where it really came up was recently Francis Gurry, the Director General at WIPO, declared 2011 the year of design. And I was recently in Geneva for the SCT, and we were working on a harmonized industrial design law. One of the things that's on the front burner is the Hague Agreement, which maybe many of you do already use. From a U.S. perspective, the Hague Agreement has been ratified by the United States, but it has yet to be implemented. From some of my conversations with some of the people inside the Beltway in Washington, I understand that the next priority after patent reform gets finalized, which hopefully will be very shortly, will be the Hague Agreement, implementation of the Hague Agreement. So I would think, and that's directly from David Kapos, the director at the USPTO, he is very keen on designs, having served as the liaison for the AIPLA's Industrial Design Committee for the last 8 years. He's very well in tune with design patent protection and its importance. So these are some of the reasons why I think that this discussion is timely and apropos. So what are we talking about here when we're talking about designs? It's all around us. We see these types of imageries where you can see on the bottom row are some of the authentic designs. On the top row you see some of the knockoff designs. Interesting is that in all of these situations, the logo or the trademark has not been appropriated. It is the appearance of the design which has been appropriated. In the furniture world, we were very accustomed to seeing these types of knockoffs. So just so we can sort of set everybody's focus here, is that in the U.S. there are 3 ways to protect appearance: trade dress, copyright, and on the top you see design patent. Each has their own requirements. We're going to focus today on design patents. But one way to think about a trade dress, we talk about things that are sort of iconic or things that we have developed as secondary meaning. You develop the customer association either by inherent distinctiveness or by secondary meaning. The copyright stuff, fair to say, typically reserved for more artistic endeavors. In the U.S., we have the useful article exception, which prevents the protection of these designs through copyright. So design patent is really the only game in town for a large majority of these items. It's the design patents. It's important to know about design patents because when we're talking about protecting an item, if you're foreclosed from trade dress protection, say for instance you have issues with functionality or if you have issues with distinctiveness, you can't go there. Copyright, you can't go there. You're left with design patents. These are just some other examples in order to sort of hammer home the differences between these 3 particular areas by way of example. You can see trade dress down in the lower left where a Tizio lamp or a Bellini chair. My heritage is I'm Italian American, so any opportunities to talk about Italian stuff I will. So take note. But the Tizio lamp, the Bellini chair, those particular things have that iconic nature. But it's important to note that with respect to the things in the lower left-hand corner of the trade dress, you can also protect those with design patents. One of the strategies that we typically employ is to first get your design patent protection because you don't have to have a product in commerce, okay, to get design patent protection. Whereas trade dress you do, right? You have to develop that customer association with the distinctiveness. So in the U.S., one of the strategies often employed is get your design patent protection out of the gate. You clear the field because there won't be less noise in the marketplace, and it will be easier for you to attach that consumer identification with your product. So by get the design patent, then after 5 years, you would have the presumption with your trade dress, and you could even apply for your trade dress registration. So you can use these in concert, develop a sort of a comprehensive plan in order to gain your design patent or your design protection. All right, today, just as far as a roadmap, we're going to talk about some of these design patent protections. I'll talk about just some of the fundamentals of U.S. design patent protection. I want to give some of my tips on the 4 most valuable ways to meaningful design patent protection. And I underscore meaningful because I think very often people, when they think about design patents, and I've heard this at so many times when I speak, is, oh, well, design patents are not worth the paper they're written on, or I've heard this thing, someone says, I was speaking at NeoCon last year, and somebody said, Mr. Karani, what do you think of the 4 change rule? Well, what are you talking about? This is, with the design patent, you only have to change 4 things and you can avoid the design patent. Okay? And, these are these type of rules of thumb that are circulating out there. But those are, of course, a falsehood because we're looking at the overall appearance, and irrespective as to whether or not you change some of the minutia, the concept here is whether or not it's the overall impression of the design. That's what we're talking about protecting. And lastly, I'll hit just quickly on enforcement. I come at most of this from an enforcement side. By training, I'm a litigation attorney, but it really informs how I also go about protecting these particular designs. So again, why this is so timely is I'm sure I've just picked a couple of jurisdictions here: the EU, China, the U.S. The amounts of design registrations and applications are skyrocketing. The reasons why are quite simple. I think just customers are placed greater emphasis upon design, and the more that you invest in that and you realize that, the companies want to protect the design. The insidious reasons, there's many more knockoffs. Okay, so how are you going to protect that? And then my last one here is more of a legal point, is the Supreme Court commentary. In the U.S., the 2 Supreme Court cases, Traffic's decision and the Walmart decision back in the early 2000s, severely curtailed the ability for trade dress protection, further making design patents the only game in town. While I'm at that, important to note too that in the U.S., in order to file a design patent, you have to have passed the patent bar. You have to be a member of the U.S. patent bar because it's still underneath the umbrella of patents. Whereas I think in many jurisdictions, to file a registration, you need not be a patent attorney. All right, and here's some just recent examples of design patent infringement awards, just to show that these things do actually get sued upon, and they actually you can obtain judgments and money damages. But in each one of these instances, you'll note that I give a dollar amount, but then I give the injunction. And oftentimes, you're catching these things out at the outset of the infringement, and the injunction is really what the client's after in these particular cases, not so much the money damages. Again, refocusing ourselves on design patents. Underneath patents, you have utility patents and design patents. The basic difference, here's an example of a case that I worked on with, utility patents for the Motorola Razr phone. There's several of those, but there's also several design patents on the outer shell of the Motorola Razr phone and how it looks. So those are sort of the 2 differences. They are not mutually exclusive. You can have double coverage. Indeed, you could have trade dress protection, design patents, utility patents, even in some situations, copyright on the same product. It really is a comprehensive package. Hard facts on design patents. 1 claim per design. So this is a little different from particularly people coming out of the European Community of Designs, where you can file multiple designs in the application. You only allow 1 design, but as I'll talk about later, you can file multiple embodiments. It's a 14 years from issuance, and note it's from issuance, not from filing. So here's a sort of a dirty little secret about design patents, is that we also have continuation practice, right, in the U.S., is that because it's pegged off of issuance, you could file your design patent, you get it prior to issuance, you file a continuation application. So this first one's going to run from year 0 to 14. Well, say you file a continuation application in year 1 where you just dot out or change some portion of it. When that patent issues, it's also going to be given another 14-year term. Okay, so you can start seeing it's a dirty little secret. I think maybe the legislation will catch up to it, but right now you can sort of daisy chain these things out and start extending your coverage beyond that. No maintenance fees. So that's clients particularly like that on designs. Maybe the USPTO will catch up to that and figure that they can find a profit center with design patents, but currently from year 0 to 14 there is no maintenance fees in the U.S. The average filing to issuance is 9 to 12 months. Now, for many people with registration systems, that seems like an eternity. They are trying to pull down that time period. For instance, here's a example where this is using the Rocket docket. You can apply for this expedited procedures. Here's less than 6 months, the recent one, less than 4 months from filing to issuance. So there are ways in which to file these things where you can get them examined in a much quicker time. Now notice I said examined, okay? Once again, this is one of the main differences between the US system and others. We have an examination system. We will be looking for novelty. We'll be looking for non-obviousness and ornamentality. So what do design patents protect? They protect the shape, surface ornamentation, color, and a combination of those three things. So that's where you sort of can get some of the synergies on these. The statutory requirements, as I said, novelty, non-obviousness, and ornamentality. Novelty, new, non-obvious, that one of ordinary skill in the art would think that was the difference between the prior art and that was non-obvious. And then furthermore, ornamental. Now that's the one I think that trips most people up, where a lot of people, they discard design patent protection. And I know, at least from the US perspective, I think in the law schools they teach about trade dress protection and these issues of functionality, and even in copyright with useful articles, that people sort of say, well, no, you can't get a design patent because it's functional. And they almost think design patents are just left for vases or something like that. But the reality is there's all sorts of things that have a function but yet are considered ornamental. Ornamental it's an unfortunate choice of words in the statute. In fact, most industrial designers find the word ornamental for their design to be almost insulting because they think of ornamental as just adding some frills to something like that, whereas this is a concerted attempt to integrate function and form. These are all issued design patents. The test is, are there any design choices? Is there anything where there was a design choice? An example of something where there wasn't a design choice, and it's the only Federal Circuit case that I know of where there wasn't, was a keyblade. Okay? And the thought there is that keyblade had to fit that keyhole, thus the designer didn't perform any designing. He just simply, the form was dictated by its function. This is a real-world case, a case that I worked on regarding a drill bit. I mean, what could be more functional? I mean, going back to Archimedes' time, you're talking about drill bits performing a function. But this is an example of how you can convince a judge in the U.S. that there are many designs. And I apologize, I don't want to make the quads a little better there. But you can see that with the shank design as being whatever shape it is, a hexagon cross-section, maybe the midsection in that can be changed. There are aspects of the design which are arbitrary, and being able to show multiple designs, you can avoid this issue of functionality / ornamentality. Those are mirror images. Here's the keyblade design. Here the court said, no, there's no design here. That's just the keyblade. You probably could have avoided this decision had you shown the key handle on there, right? Because there was ornamental choices, and the determination is the overall appearance. So as long as you include some non-functional elements into the overall design, you can avoid this issue of functionality. Color combinations, these are just some examples of, for instance, Apple's use of the color combinations. If you don't specify, you're entitled to wildcard. It's any colors would fall within the scope there. But sometimes companies, even particular with respect to trade dress issues, trying to develop this I know firsthand, this is Apple's strategy here, is to actually file narrow design patents to claim a specific color that will aid them in developing their distinctiveness for their secondary meaning with respect to their trade dress protection. Color contrast, you can also think about these things as that you don't have to specify the color, but just that you have a light and a dark color next to each other. So if you haven't seen a design patent, in short, you have a title, you have a claim, a specification, and then the drawings. The drawings are the property line. There are no written descriptions. It is just the pictures, typically from 7 orthogonal views. In this particular design patent, there was just 6. But from the top plan, side elevation views, and those type of things. That is the property grant in a design patent. So now on to the 4 ways. And these particular techniques, they are allowed in the US. I know in many other countries they are not allowed. So you would have to adjust if you're looking to claim on a global scale. You might want to, if you first were to file in the US as your priority document, you might want to file a second set of drawings that would be compliant with your particular jurisdiction. I know, for instance, as the first one I'll talk about here is broken lines. Whenever I file cases that will also be filed in China. I'll file a second set with the USPTO, which does not have broken lines, so that I can use that as the basis for my priority document, because the SIPO office has changed their policy on whether or not they will accept dotted lines or broken lines. And then if you do add solid lines later, they will consider it new matter. So I'll explain a little bit about that. So here's 4 ways to increase the scope and the value of design patents. Fido is here, okay. He's the next speaker. All right, so broken lines, dotted lines, phantom lines are all the same thing. And a little bit about why you would do these. Okay, here's an example. A lot of these examples come from the furniture world, which I've done a fair amount of work in, and I think importing some of the conventions, the drafting conventions from that particular industry to other areas is something that's been underused. But this is sort of a more fundamental one, is using these dotted lines. So for instance here, what we're claiming is the top portion of the chair, the portion that's in solid lines, whereas the bottom portion of the chair, which is in dotted lines, is not claimed, effectively creating a wild card. So as long as you have the top portion of that chair, irrespective of the bottom might be 4 static legs, in other words, they're not on rollers, it might be just 4 legs or 3 legs, or maybe just 1 post, or maybe this seat could be a seat on an airplane or on a bicycle, who knows? It does not matter what is in the bottom, it's just providing some type of environment or some types of context. So that's one way. Now why would you do this? Is that if, say, somebody just wanted to copy the top, if you put everything in solid lines, and say somebody did want to use this for a lawn chair or something like that with just 4 chairs on it, they would not copy the bottom of your design, they just copy the top of the design, and you couldn't go after them for design patent infringement, because your claim covered the entire thing, including the shape of the legs. So the overall appearance of the 2 designs don't look substantially similar. So the key here is to ferret out those particular aspects of your design that you want to protect, and it might require some of these things we'll talk about with multiple applications and what have you. There's another example of a table where you just eliminated the feet, and also you can see that the hardware on the hardware here, that's a very common thing, is to eliminate the hardware, because that's low-hanging fruit for design arounds and people to change the appearance of the design. Now, if they start the amalgam, remember, if they make 4 or 5 changes, maybe that would be enough to change it. Not always, though. Here's an example on some footwear. And we know here in the States we're considering these new fashion design bills and stuff, but design patents is also another way to protect these things. So here, irrespective if that toe portion was perhaps on a ski boot, I don't know, but it could be on anything. So it doesn't have to be on a pair of women's flats in order for the protection here. That particular design on the toe can appear anywhere else. These are some other things we do for some clients with respect to logos. No need to have logos in your design patents. I see this a lot when I get cases from foreign filers filing in the U.S., and they'll give me drawings that have the logos on. Your trademark protection will provide that already. What we're trying to protect here is instances where people remove the labels, or perhaps the product does not have a label. It's the design which is driving the consumer appeal. So another way of using dotted lines is you can sort of... Okay. We started a little late. Is in order to put these on the bottom, you can sort of show a common thread which goes through the design. Okay, indeterminate break lines. So this one's sort of a simple one, but completely underused, is where you want to change the aspect ratio of a particular design. And so the length times the width. So you can use these things, you can see them being used. Here, the sofa could be a love seat, or it could be a sofa. It can expand. Or, here with respect to handles or with respect to towel racks, you don't want to be limited to the particular aspect ratio. Therefore, you can use these types of break lines. This is in a case I filed. In fact, I was the inventor on this. I actually here changed, I got the USPTO to agree to radial expansion. So not in a linear fashion, but also in a radial expansion with things showing that back plate can shrink or can increase in its diameter and still be within the same type of claim. Okay, number 3, multiple embodiments. We said there can only be one claim, but the office will allow you to file multiple embodiments so long as they form part of the same distinct look, okay? And there's some leeway here, and this is where you can sort of push the envelope with the USPTO. Here you can see the one embodiment with 1 leg, and you got 2 legs. They still have that same common thread between the 2. And you can even start pushing it further sometimes with 1 embodiment here. claiming the furniture here, furniture examples, some with arms, some without arms, some with backs, some without backs, pushing this into one claim. Again, the key here is adding value to your design patents by gaining scope. So you get away from this notion that design patents are so narrow and they don't have any teeth. Well, they can have teeth if you take a learned, strategic approach using these concepts and these drafting conventions. Also then, one of the common approaches is with respect to multiple applications. File distinct applications on the discrete, novel, valuable parts of your application. Don't just file it on the whole shoe. File one application on the sole if you care about it, and another one on the upper sole. Through continuation practice, oftentimes what I'll do is I'll file the first one in solid lines and then file continuation applications, systematically eliminating aspects. Maybe I just want to claim the top, maybe I just want to claim the bottom, maybe I just want to claim two legs, maybe I want to claim a leg and the top. This is how you really create a sticky situation for people who are trying to copy your client's products. You can see Apple, here we've used this particular thing with Apple. You can see, the click wheel sometimes, the click wheel and the screen, then maybe not the click wheel and the screen, and maybe just the no screen. So you can see that you start using these permutations. You use them all together, you can start really creating some valuable protection here. The synergistic effect, this is a real world example. Here I filed with dotted lines, indeterminate break lines, multiple embodiments, another application, multiple applications, really creating a network. The key here is be creative, be an abstractionist. Try to abstract out what's the key part of the design, abstract it out. What is your competitor really going to copy out of your design? Okay, I'm going to go 3 minutes here on the design patent enforcement, just so you know what is the test. Okay, what can the clients be expecting? Here's the granddaddy of them all. This is the case. This is from 1871. This is the U.S. case, which is still the law today, and it's cited in every design patent case. Gorham v. White. I actually have both the Gorham spoon and the White spoon in my office in Chicago. So I'm a real design geek. So this is the test. In the eye of an ordinary observer, two designs are substantially the same. The first one's infringed by the other. That's it. It's simple. It's substantial similarity, not identicality, not a blueprint, but is it substantially similar? So what happened in Gorham? Let's take a raise of hands. Who thinks that there was infringement? The patent's on the left, the accused design's on the right. Who thinks there's infringement? We got one. Who thinks there's non-infringement?
Obviously there is.
There's infringement. Okay, Zev, you got it. So infringement in that case, that could be your sort of barometer. Maybe when you're judging your own clients, is there infringement in the U.S.? Maybe take out these slides and say, are we closer or further away from these two spoon handles? Bringing it up to the current day, 2010, here's the famous Crocs case, right? Patent on the left, the accused design on the right. Was there infringement? The court held yes, infringement. In fact, the overall effect, despite the fact that there are differences in the hole size and the shape and the placement, that there was infringement. And the remedies available in the states, lost profits, reasonable royalty, infringer's profits. That sounds different, right? Because we don't have that in utility patents. So you can disgorge the infringer's profits, injunctions, preliminary, and permanent. So I made it through in time. Thank you very much. We'll take questions if you have any. Otherwise, we'll move on.
Patents.
Yes, well, we can do that. So, actually, I think with the time up, let's circle back to the other people, and then we can go through those patents, okay?
Okay.
All right, we have a quick question here.
So actually, it's a comment.
Okay.
Remember, design patents are patents. They're subject to the disclosure rules.
Sure.
So you have to have information provided to your U.S. attorney relative to what you know that would have to be considered by the patent office. A lot of people don't think about that.
Yeah, no, I think it's an excellent point. So the comment here was that there's a duty of disclosure. So when you are filing, I don't like you're filing a trade dress registration. If you're filing a design patent in the U.S., if you know of any prior designs, prior art, just like with a utility patent, you need to disclose that to your U.S. Attorney prior to filing, or else you could suffer inequitable conduct. So good comment there. Anyone else? But I know we've got a strict timeline. So
There's also time for questions for everybody. So
oh, sure. Okay, at the
we'll
end?
all
Or?
meet and ask questions together.
Okay, so we can do that at the end?
Yeah.
All right. Well, if anybody has questions, I'll be around, so I'll be happy to entertain any questions there. Again, this is this area of design law, whereas I practice also, intellectual property, generally speaking. I think that this design stuff should be on everybody's radar screen because I think it's effective, it can be quick, and it actually can have some teeth if you do it right. So I'm happy to entertain any questions or comments afterwards, but I'll pass it on to the next speaker.
Okay.
Thank you.